Good morning. The hearing board of the South Coast Air Quality Management District is in session. Today is Tuesday, November 14th, 2017. The time is approximately 9:20 a.m. and we are meeting in the hearing board room in Diamond Bar. There is one change to the calendar today. Thumbs Long Beach Company, case number 2515-20. Short variance is off calendar. We have one matter for today, and that is SCAQMD versus Everardo Avalos Lopez, case number 6090-1 for an order for abatement. And this matter has been continued to allow more time for the respondent who did not show at the last hearing to have more time to show. Who is representing the executive officer today?
Brian Tomasovic, Senior Deputy District Counsel for the Executive Officer and Petitioner.
Thank you, Mr. Tomasovic. And I see no one here for respondent Everardo Avalos Lopez, but I'm going to ask if anybody is here to represent the respondent today. Seeing none, I'm going to turn it over to you, Mr. Tomasovic, and I'm just going to remind the board that at the last hearing, we had significant testimony. We also had declarations by several people with regard to whether or not we were going to hear the case in absence of the respondent being present. And just to remind the board that we may do so under our rules and that we received a good amount of testimony to back the district's positions that the case should go forward in absence of the respondent being present. Mr. Tomasovic, if you don't mind perhaps giving us an opening, reminding us where we stand on that, and even though you were not required to do so, I know that that the district undertook additional efforts to try and contact the respondent, and if you could briefly summarize that, I appreciate it.
Yes, the district maintains its position that service was accomplished against the respondent in this case by the board's continuance. He has had an additional opportunity to appear or communicate whether he needs additional time or anything, and at least to myself as counsel for the respondent, I don't have any communications that are helpful in that regard. On the 9th of November, we filed a document called Notice Regarding Efforts to Contact Responding Party. We agree that these were courtesy efforts that weren't required, but they do indicate that efforts were made to see whether respondent had an interest to come in, and as is now a record matter, he has failed to appear for this hearing, whatever his intentions or reasons for that. We can proceed. The petitioner does not carry a burden of explaining why respondents failed to appear. We think that that is an appropriate way to move forward in light of the way that adversarial interactions work as a practical matter. You'll see, in fact, that one of my first efforts to communicate was on the day of the last hearing, which included my sending an email, which even included a point of contact and link to the hearing board, clerk of the board. So the respondent efforts have been made to provide the information to respondent, including even his sharing information of his opportunity to request a language interpreter if he desired to do so. And therefore, we think, as with the last time of this hearing, October 25th, the petitioner is ready to proceed in respondent's absence and put on evidence for an order for abatement.
Thank you, Mr. Tomasovic. Board members, I think it's appropriate at this time. Well, first of all, as a preliminary matter, we don't have to mark anything that you've submitted and was date stamped. We also received this morning a declaration of Ken Matsuda, but I will note for the record that we already had, it looks like this exact declaration. It was attached to the notice of intent to introduce documents as exhibits, and it was submitted in October. Is there any difference, or is there any reason why we received that today?
I can't speak for the distribution. I can say that this morning I provided 5 different declarations, all stamped original with original signatures, and they are the same as those declarations that were previously filed on October 20th. There is a small point of confusion that I'll mention now. In my filing on the 9th, on page 2, I suggested the declarations were previously filed on November 17th. This is under the 4th bullet. That was my mistake. I was misreading, not accustomed to the format of the clerk stamp, and so I put 17 instead of the 20th, which was in fact the date that we filed the 5 declarations.
Thank you for that correction. So then we won't mark, we'll just put aside anything marked original declaration. We already have that, and we're going to leave them as they already are attached to the notice of intent to introduce documents as exhibits. And with that, board members, I think it's appropriate at this time for us to have a discussion amongst ourselves with regard to Rule 7 of our hearing board procedures, 7B2, with regard to attendance at the hearing, which states, and I will read it again into the record, if the responding party fails to attend the hearing and the petitioning party has provided the hearing board with proof of service on the respondent of the petition, the hearing board may rule on the petition in the respondent's absence. And given the word may and not shall, I think it's appropriate at this time that we have that discussion as to whether we wish to proceed in the absence of respondent. Mr. Camarino, would you like to start that discussion?
Yes, I think it is appropriate to proceed in the absence of respondent. The district, at our prior hearing in this matter, provided evidence that all of the requirements, notice requirements had been met, and this board felt that under the circumstances that perhaps an extra effort should be made, and I believe that an extraordinary extra effort was made to contact the respondent, and the respondent was given additional time, was given opportunity to request a translator if one was needed. Respondent is not here today. I think we've gone above and beyond, and I think we should proceed.
Thank you. I do agree, and I want to go back to also the last hearing and recollect that the testimony was that when the NOVs were originally served, and there were 2, Mr. Everardo was spoken with in Spanish. Also, there was testimony that his son was directly addressed and that his native language is English. Mr. Everardo could not be served, and as a result, as is appropriate under the rules for service in civil proceedings, the respondent was properly served by substitute service, and the recollection from the testimony is that it was the son who was served. And I think this matter has been ongoing. I think the first NOV was from 2015. And I think that respondent is well aware of the issues. He's been made well aware of the issues. And as Mr. Camarino, you point out, extraordinary service above and beyond, and attempts to contact respondent and to let him know of this hearing were made by the district. That is not required of the district, but the board felt more comfortable if the district would do so, and the district has done so. And yet the respondent still has failed to show today. And I was thinking about this case from the last time that we heard it, and I think that there's a bit of a difference. I know that this board is very conscious of and very sensitive to the fact that there are many members of the communities that the district serves that either might not legally be here or that do not speak English natively. And in the past, we have had a lot of discussions about people who might come to testify before us, who might be impacted or affected members of a community, who might be reticent to give their names or appear before government agencies. And we have been very sensitive to that when these people are might want to come as witnesses when they are put upon by pollution or they are affected, they are exposed, they are members of an exposed community. But I think we have to look at this type of case differently. This is an individual who is choosing to do business in the South Coast. And this is an individual who, just like all other individuals, must comply with the rules of the district as well as all other rules and regulations that may apply to his business. And if this board does not hear this case, despite the fact that he has been properly served, and singles him out because he does natively speak a different language or may not be from this country originally, we allow him to operate at an unfair advantage to others who are legally following the rules. And as a result of everything we see, I do believe that we should proceed and hear this matter. Anyone else have? Ms. Bird?
I agree that we should proceed. There have been times, we have had issues, we've had cases like this before when maybe someone did not come to the hearing. In this case, from my notes, I see that even when Mr. Enriquez spoke on the phone, when it was clear of what he was trying to explain and tell the individuals, that they hung up the phone, okay, and that he called back and they hung up again. So I think it, and then as well, there was an incident where where Ms. Sanders spoke with him, and he, let's see, she said she spoke with him in both English and Spanish, and the son indicated that he would also explain to his father. And when asked about inspecting the equipment, he remembered the first NOV, and became upset when she asked about permitting or registration. So I think that there's a clear understanding of what was needed. And I also wanted to address just briefly, I was not an air quality inspector, but years ago I did consumer health protection as an inspector, and it was the practice during that time that if you are out in the field doing your job and you see a violator, that you do stop when you can. I know that's the practice. You do stop when you can to try to deal with that violator. And it's a part of the job. It's probably one of the more difficult parts of the job because usually you're dealing with someone who's antagonistic. So I know that procedure was followed, and I know that procedure is, quote unquote, within the normal realm of the job. The other thing that I wanted to say was, in this case, sometimes we look at small businesses and say, well, it's a small business, and so we should give them a break. And I will say, on occasion, when small businesses come before us, we do have we give them some leniency when they come in and explain their situation. It may not be a cease and desist today. It might be, next week you said you can get that equipment. Okay, let's give you to next week to get that equipment. But in this case, that did not happen. We got no responses. The district spoke to respondent, and got no responses as to how they would even be willing to come into compliance. And so for that reason, I think that we should go ahead and have the hearing today.
Anyone else wish to? I should, by the way, I should apologize and correct for the record. I referred to respondent as Mr. Everardo. That is his first name. I think I was confused because in various iterations of the name of the business, it is Everardo, but it is Mr. Lopez. Anyone else? Senator?
It's been stated that the respondent was served, and the type of service was a substitute service. Speaking from experience, having been subjected to a substitute service, and when I finally went for a hearing, the court threw out the substitute serving and required they properly serve me. In this particular case, there are sets of unusual circumstances which exist. The climate as it exists today in our country, where if you have a Spanish surname, you're more likely than others to be harassed whether you're a citizen or not a citizen. Let's assume that based on the evidence where there's been no response to this hearing, that that person who have lived in this country for a number of years may not be legal. I'm not saying that he isn't, I'm saying he's not, but may not be. And given the set of circumstances, may be afraid to appear in a legal setting, thinking that they may be arrested, apprehended and arrested, and further action could be taken. It also says in this affidavit by Teresa Gallagher that they were informed of the possibility that the respondent have some business assistance from the son. May have a business assistant. There's no assurance that that's the case, even though they may have lived together at one time or another. I don't even know that to be a fact. But I do understand today that basically what I see on TV, these people are harassed, not just by local government, but by the President of the United States of America. And I got to tell you that there's nothing more horrifying than that if you've been victimized to that extent. We don't know that the person will only break the law knowingly, but the evidence shows that he's in violation by even not coming to the hearing, but he's not been served properly, in my view. You can proceed if you choose. I can't support that. I know you've done your job, you've done due diligence, but these people have been so victimized that it breaks my heart. They're a small business, yes. If you're a bigger business, I may have a different point of view. But for this, until he's properly served, if it's possible to arrest him, if we can find him, I don't know. I can't support it. A substitute service in this case, and proceed to the hearing, even though there's evidence that the vehicle is being used in violation of the rules and regulations of the district. That's just my opinion.
Thank you, Senator. Just a few comments in response. First of all, substitute service is a legal manner of service that is allowed under the rules of civil procedure. And the reason why it exists is for those situations, which unfortunately it seems to be in this case, where a respondent or a defendant purposely evades service and makes themselves makes it so that they cannot be brought to justice. It was followed properly, and in fact, I think in this case we can have solace that it wasn't just left with any person who is over the age of 18. It was left with his son, who was with him in the past during the service of the notices of violation, who had demonstrated to the inspectors in the past that he was extremely knowledgeable about the situation and was natively fluent in English, and could and does speak to and for Mr. Lopez. So in this case, I believe not only is it legally appropriate, but I do believe it is factually appropriate. With regard to harassment, I do believe that might be a real issue for a lot of people in Southern California, in the United States, in this climate. There is zero evidence of harassment in this situation. We heard from the inspector at the last hearing who said that it is the normal procedure of the district and district inspectors when they are passing by something that does not, a piece of equipment, especially portable equipment, where you have to catch it. There's no single, it's not a fixed location, thank you. It moves. So when you see it, you need to inspect it. And that is what happened in this situation. Not that a person of Hispanic origin was seen and so there was any harassment on the part of the inspector. There is no evidence of that. In fact, there's evidence to the contrary. And I just want to say that, again, I just want to go back to my initial comments, which is this is very different from an unintentional witness or an unintentional member of a community who is experiencing an air pollution problem or a nuisance and is afraid to come forward for fear that they might be deported or arrested. This is a person who is affirmatively choosing to do business. That person needs to follow the rules, same as everyone else, or we give them a free pass. And as Ms. Bird said, I have to agree with Ms. Bird about the fact that we do often make accommodations for small businesses and for people who may not have really fully understood, but they do come before us and they give their side of the story. In this case, the respondent has twice chosen not to show. And so I believe that we should make a motion and hear the matter. Senator.
You responded to, let me just elaborate a little more. No harassment as relates to this case, probably an accurate statement. But the climate, as I stated early on, in this country at this time, where people with Spanish surname are being harassed daily. And so therefore that permeates the whole community. And I got to tell you, that is a good likelihood that's what this individual is reacting to. It'd be nice to say if someone served his son and say, look, we can assure you that if your father shows up and respond to the question, that there's nobody there that's going to require him to be arrested. I answer any question that's federally, you might get a better response.
May the district be heard on an objection?
You can't give a guarantee on that, but I'm just saying, this is not this body is not out to arrest anybody here, legal or illegal. The point should be made so the person be more likely to show or not to show. I think that's going to be a little above the quality of our responsibility as well. But I can just understand why they're terrified.
Mr. Thomas, I don't think it's necessary. I think at this point we're in discussion. I think if no one else wishes to be heard, I'm going to make a motion, and because I think at this point we do need to make a motion. I just refuse to set a precedent that anyone with a Hispanic surname does not need to appear before this board and does not need to follow the rules of the district. And so, given that, in the matter of South Coast Air Quality Management District versus Everardo Avalos Lopez, case number 6090-1. I move that we hear this matter in the absence of the respondent now failing to appear twice, having received ample evidence from the district of proof of service on the respondent as being proper service, and I'll end it there. Is there a second?
I'll second.
Thank you. Any discussion on the motion? Senator?
I'm going to vote no for the reason that it has not been established that the respondent has received the notice of the complaint against him. He was not directly served. It was a substitute service for that person. And the climate in this country being what it is today, I have to vote no.
If this gentleman is in business, I believe he's avoiding service.
Excuse me, I didn't hear you, Mr. Camarena.
If this gentleman is in business, I believe he is avoiding service.
Okay, if there's no other discussion on the motion, there's been a motion, a second. Did you have a discussion? Mr. Camarena, how do you vote? I know you
I
seconded.
vote yes.
Ms. Byrd, how do you vote?
Yes.
Dr. Lerner, how do you vote?
I vote yes, but I'd like to make a comment, which I should have made when the discussion was open.
Please.
Just, I side with what you're saying, but I understand Senator Holden's comment. It would have been, in the perfect world, you need to have someone mano a mano, face-to-face, handing the person a notice of violation, and he can look in your eyes and say, you're not going to be arrested, you're not going to be jailed, nothing's going to happen to you. This is a legal matter, not about your immigrant status, but the status of a permit, which you don't have. A lot of this, in my business, everything is face-to-face. You can convince a person by looking at them and discussing it with them, as opposed to handing them a note saying, these are your lab results. It's an analogous situation, not perfect, but it is operative. I do vote yes, but I just wanted to state that for the record. A little compassion, a little direct meeting with the respondent would be appropriate.
Dr. Lerner,
Can't meet face-to-face if he's avoiding you.
Dr. Lerner, just to be clear, you mentioned the NOV. The NOVs were served directly upon there was testimony. They were served directly on respondent. There were many face-to-face conversations. We're merely making, the motion is merely to hear the matter because proper service was completed. Senator, how do you vote?
There's no evidence. There are many face-to-face. No evidence of that.
NOV
Okay, so
is,
therefore,
NOV is face-to-face.
I'm voting no.
Okay. What there is no evidence of, by the way, on the record, is that this man is even of illegal status. Mr. Tomasovic, the motion passes 4-1, so we will hear the matter. Mr. Tomasovic, do you wish to make another opening on the merits? And will you be presenting witnesses, or do you wish to stand on your paper?
Madam Chair, I'd like to make an opening statement and then proceed to offer evidence. I'll be brief and expedient, as I hope this hearing may be. First of all, to allay misinformation. I do not serve in a criminal attorney capacity for the district, and I wouldn't represent myself as that in any of the conduct of the district's business. There is a danger in assuming facts that are not in evidence. This goes a bit outside of the record, but we have done a background check on Mr. Avalos Lopez, and based on that, I would not assume that he is here in any unlawful status. And to go into further detail would infringe on his privacy in ways that I don't think are appropriate or relevant to the issuance of an order for abatement. In support of all of the necessary findings for that order for abatement, the petitioner intends to submit Exhibits 1 through 6 that were attached to the petition for an order for abatement at its filings, and to identify the relevance of those exhibits and provide an appropriate measure of authentication. The district will intend to submit the 5 declarations that were previously filed with the hearing board in a filing on October 20th. This evidence will establish that the respondent is in violation of District Rule 203A, operating equipment without a permit, even though this equipment is of a size and type that would necessitate a permit. The evidence further shows that this equipment is portable. District personnel cannot easily track and confirm whether or not this respondent is in compliance. The uncontroverted facts will be that the district has issued 2 notices of violation to the respondent with all of the resource commitments that that entails, and he has not been communicating with the district in any way that makes our job of confirming and securing permanent compliance any easier. This need not be seen as anything more than a strict liability violation. The board does not need to dwell on the respondent's motives or his understanding, or even his understanding of district rules or enforcement efforts. The simple fact is that we had to issue 2 notices of violations, and all further violations, whether or not we catch the equipment in the act, is an offense to the rule of law. Therefore, we today require an order that makes the respondent cease and desist in the conduct of operating equipment without a permit. Proceeding to the evidence that we would offer, we ask that you receive Exhibits 1 through 6 attached to the petition for an order for abatement. In sequence would probably be most convenient.
We will mark Exhibits 1 through 6 as they appear attached to the petition for order of abatement. And Mr. Tomasovic, would you like those to be in evidence?
Yes, Madam Chair.
They are in evidence.
Proceeding now to the declarations, I draw the board's attention to our filing entitled Notice Regarding Efforts to Contact Responding Party. This was filed on the 9th of November. Exhibit 3 to that notice has my email to respondent's son dated November 2nd, and there were PDF attachments to that email, including a letter with the caption Evidence Upon Affidavits Rule 8C. The letter is dated October 31st, 2017. I can represent that this was placed in the mail and duly served upon the respondent by the authorized methods. Rule 8C, the board may not be entirely familiar with it, but it allows any party, whether that's the petitioner or respondent, to propose that affidavits will be submitted into evidence without need to call persons as live witnesses. And when affidavits are received under that rule, it is treated as testimony. There's it is not treated as hearsay evidence. You will note the footnote of that letter refers to California law. There's a California Code of Civil Procedure, section 2015.5, that says declarations can be admissible as affidavits, provided they're executed in the proper form. And in this case, the 5 declarations that were previously filed with the board are in the proper form, with language saying they were executed under California law, under penalty of perjury, here in Diamond Bar, California. As such, these declarations are appropriate for admission into evidence under Rule 8C, and we'd ask that they be received at that time. Just to name what they are, there's the and this is the order in which they appeared in our first filing. They are the declarations of Amanda Sanders, Mauricio Enriquez, Ken Matsuda, John Cavoto, and Teresa Gallagher. And so we move for their admission.
They are so admitted.
With that, the district believes the hearing board has all the evidence it would need to make the necessary findings. We can proceed to my closing argument, or I can hear any questions they may have on points of law.
Board members, Mr. Tomasovic has indicated that he wishes to proceed as he is entitled to under Rule 8C by affidavit. So he will not be presenting any witnesses for factual questioning. Does anyone have any questions of law? Senator?
You stated in your opening statement that 2 notice of violations were issued. How were they presented to the respondent? Directly or by mail?
The 2 notices of violation are now received as Exhibits 1 and 2. It shows the date of their issuance. One is in 2015, one is in January of this year. One is signed by Everardo Avalos, who is the respondent. The Exhibit 2 is also signed by Everardo, well, served to Everardo Avalos. He did not sign. The notice of violation was prepared by, in each case, by district inspectors who filled it out, and by their declarations, which were also received into evidence, explain how that they identified him, and it includes their testimony to the fact that these were served on respondent. So,
And may I, Senator, may I direct your attention to the declarations of Amanda Sanders and the declaration of Mauricio Enrique, and therein each, and I think it actually is. No, those are the NOVs. I am referring to notice of intent to introduce documents as exhibits, date stamped October 20th, 2017, from our prior hearing. There's the first declaration is declaration of Amanda Sanders. The second is of Mauricio Enriquez. These were the 2 inspectors who issued the 2 NOVs. And if you look down on the first page of each, there is an explanation in each affidavit of the manner in which the NOVs were presented and served.
This gentleman here was saying that they were issued, and he didn't use the name Lopez. Were they issued in the name of Everardo Avalos Lopez?
I don't think it's appropriate to ask Mr. Tomasovic. Let me just
He
finish.
made the statement, he had an opening statement, I want to know if he's correct.
Understood. But Mr. Tomasovic is not testifying as to factual matters. What Mr. Tomasovic has done as the attorney is to present to this hearing board a case on papers. And he has walked us through the rules, our hearing board rules, which allow him to do it in this manner. And he has also directed our attention to where all of the evidence can be found for this matter. So it is not appropriate to ask Mr. Tomasovic factual questions because he cannot present evidence that this hearing board can consider.
Without reviewing Exhibit 1 through whatever, is the NOV issued in the name of Mr. Lopez?
Senator, you need to have in front of you Exhibits 1 through 6, and if you do, which we should, because we are ruling on this case today, then we can see notice of violation and who it is. I can't answer evidentiary questions either. It says what it says. And I will say also, though, although we're not in discussion yet, we could allow Mr. Tomasovic to close, and then we can be in discussion. However, I will say that throughout the papers, it is noted that the name of the business changes, and it has, and that Mr. Lopez has done business under various names, including Everardo's Tree Service and Everardo Tree Service. And so if the name Everardo is on the notice of violation, it is because of how the business has been presented and the name of the business.
I just want to have all the evidence before I cast my vote finally. And I think you stated early on that you did a background check, and he has legal standing.
That is,
I ask you, is that written anywhere?
that is neither relevant nor is it appropriate. And I
Relevant
think
to me.
Mr. Tomasovic made a point that that would impinge upon respondents' right of privacy. And that is not something that we can entertain as evidence for the violation of South Coast rules, which we are determining today.
If it makes a difference to me whether he had legal standing or illegal.
It shouldn't make any, let me just say that the only thing that we should be looking at today, now that we have determined that service was proper and that this hearing should be held, is whether or not this equipment exists, whether it has been used, whether NOVs have been issued, and whether it properly and legally may be used in the South Coast, according to the rules
For
of the
your
SCAQMD.
information, I would be persuaded by the fact, if he had legal standing, then he's obviously avoiding service.
We are no longer on the question of legal service.
All right, carry on.
Not to invite a back and forth on factual questions, I can quickly point to the two parts of the record that make clear this up.
Thank you.
The declaration of Amanda Sanders in her paragraph 5 provides testimony that his identity was verified by inspection of his California driver's license, and that was in the name of Everardo Avalos Lopez. The respondent goes by two different last names, sometimes the full last name, Avalos Lopez, and sometimes Avalos. And that's the name that was used on the notice of violation was what our inspectors relied on by his representations. If you go forward to another declaration, which is the declaration of Mauricio Enriquez, and look to paragraph 6, you'll see the same information that Inspector Enriquez, for purposes of identity verification, examined the California driver's license with the same ending in the same two numbers, and observed it to display his photograph and the longer personal name Everardo Avalos Lopez. So in this case, the district is quite confident that the respondent is properly identified, and the name that is in the caption is the proper name.
Thank you, thank you.
I think at this time it would be appropriate then, Mr. Tomasovic, if you could give us a closing, and that was extremely helpful. Thank you very much. And if there's anything else you wish to point out in the papers, by all means, please do so.
Thank you.
I'm sorry, before I do that, is there any member of the public who wishes to be heard on this matter? Seeing none. Mr. Tomasovic, your closing.
We shouldn't overcomplicate this case. We have two notices of violation against respondent. These are Exhibits 1 and 2. All of the other evidence is explanatory and corroborating for how these notices of violation came to be issued. The equipment is portable, and we cannot trust that respondent has ceased the use of the engine. Therefore, the NOVs establish the need for an order for abatement. They give you what you need to make the finding that respondent is in violation of a district rule. Moreover, the order for abatement will not constitute a taking without due process of law. District Rule 203A is a rule that has long been in effect. The requirement and expectation that the rule will be followed is not a taking. Moreover, the opportunity to participate in these proceedings was provided to respondent. Whatever his reasons in failing to appear, the petitioner has followed its rules. The hearing board will be following its own rules in issuing the order for abatement. There is not a taking, but in any event, we should all be confident that due process has been afforded to the respondent. Last, we don't necessarily have evidence that respondent has a, quote, otherwise lawful business, but we also don't need to go there or be concerned about the conduct of this business according to requirements for businesses that are outside the jurisdiction of the district. What we can say, because of logic and common sense, is that a cease and desist order against the operation of a wood chipper engine in the district is nothing close to closure or elimination of an otherwise lawful business. It is a tree service business, not a portable wood chipping business. The only part of the business that is arguably being closed, if we would use that concept, is the part that is not lawful and not permitted. The evidence shows that respondent has twice been caught operating a relatively unclean diesel engine in the South Coast Basin. In fact, this was in parts, the eastern parts of the basin, that can use those beneficial reductions in air contaminants. In other words, the evidence supports all of the necessary findings for the issuance of an order for abatement under District Rule 806. We understand the board will decide the issue of duration. I would issue that the duration be long because the power of the order for abatement will lie in two things. First, although there is more of a concern for obtaining permanent compliance, higher penalty exposures do attach to each future day of violation of an order for abatement. But second, the district needs to be empowered, among other things, to seek out civil injunctive authority of California courts. So if the order for abatement is due to expire in the hypothetical course of litigation before California courts, it will not have much value. And I do not see that the statute envisions a scenario where we would come back to the hearing board to prolong the order's effectiveness when in fact we need to do active enforcement in such a scenario. With that, the petitioner asks that this board, in accordance with California law, issue the order for abatement.
Thank you, Mr. Tomasovic. Before I open it up for discussion, I had two questions for you, or a couple questions. The proposed findings and decision for order for abatement that was presented to the board at the last hearing, do you intend to make any changes to your proposal? And in particular, does the order make sense as it is a cease and desist until such time as the respondent submits a complete application to operate the engine? And this, from my understanding of the testimony by affidavits, this particular engine cannot be permitted? Or is it just a straight cease and desist?
The language of the draft or the proposed order for abatement says until such time as respondent submits and the district accepts, emphasis on accepting an application for a permit to operate the engine. It is not expected that there would be any change to California law that would allow this engine to be registered on the portable engine registration program done by the Air Resources Board. So this goes into details that are covered by the declaration of Ken Matsuda. There is an outside chance, which isn't strictly part of the purview of the board today, that there will be a change to air toxic control measure laws at the state level that could open up flexibility for air districts. It doesn't necessarily mean that this air district would allow the permitting of the engine to say that it meets BACT, but there is that possibility, and that is a decision for the permit authority at a future time, even assuming that an application could come in. So I would suggest that the language is at least workable from that standpoint, and to the extent respondent or his son is watching the proceedings today, I would encourage him to be in contact with me, and I can refer him to district personnel to give a firmer answer as to whether, if he is interested in obtaining a permit, whether he could obtain a permit. But I can't give that answer, and no witness of the district could give that answer today. But in any event, I do invite him to contact me. It is part of our job to, assure compliance and give advice to folks that if they can get a permit or they can be eligible for a permit, try to give them accurate advice. As it stands today, he can't obtain a permit. A permit would not be accepted.
Thank you. And then the other question I had was, do you have a suggested or proposed date by which you would like this, this board to consider retaining jurisdiction?
According to what we strictly have for the evidence of the last date of violation, I would propose that we go forward 3 years from then, just to match up with the statute of limitations, which would be
January 2020?
January of 2020.
Thank you. Board members, discussion? Anyone want to begin discussion? Anyone like to begin discussion?
I thought you wanted to be.
I want you to go ahead.
You want me to go first?
Senator, go ahead.
Oh, boy. Poor Nate. I think the exhibits 1 through 6 is not in evidence, is that correct?
They are in evidence.
Right. When you look at exhibit 1, which is notice of violation, it just says Alvarado, and the address is crossed out. So what address is applicable? In what way were they notified? And they were, what address? Is it Richards Place and 4th Street? Because you got, they all crossed out as a mumbo jumbo here.
Everardo was identified because that is in the name of the business. The address, I can't speak to that, but I will read to you from the declaration of Mauricio Enriquez, who served this first notice of violation in paragraph, let's see, where would I start? He says, in paragraph 5, I'll just read it all into the record. I am the inspector who issued notice of violation P63954, a copy of which is attached as Exhibit 1 to the petition for order for abatement, etc. This NOV was issued at a job site near the intersection of 4th Street and Richmond Place in the city of Rancho Cucamonga. District Inspector Amanda Sanders accompanied me in the course of the inspection that led to the issuance of the NOV. On October 23rd, this is paragraph 6, 2015, I personally served NOV P6954 as initially issued on an individual who is the respondent in the petition proceedings, and I explained to him the reason for the violation. The individual to whom I served NOV P63954 identified himself as, quote, Everardo Avalos, unquote, and the owner of a tree service business he called, quote, Everardo, unquote. That's why it's in the NOV. This individual also identified himself as the owner of the wood chipper engine that I observed on that day to be in operation that is the subject of this NOV. For purposes of identity verification, the individual presented to me his California driver's license, which I observed to display his photograph and the longer name Everardo Avalos Lopez.
Well, we have exhibit number 2. Same thing, Everardo's, we crossed that tree service.
Same thing.
That's it, NOV 65509.
And that one was served by Ms. Sanders, and her declaration states, on January 10th, 2017, I personally served NOV P65509 as initially issued to the individual who is the respondent in the petition proceedings, and I explained to him the reason for the violation. The individual to whom I served NOV P65509 identified himself as, quote, Everardo Avalos Lopez, unquote, and his identity was verified by my inspection of his California driver's license, and my recollections from having previously met this individual when I accompanied District Inspector Mauricio Enriquez to witness service of NOV P63954. The NOV was first issued against Everardo's tree service, but this was later amended to Everardo simply to match the identification that was being used in existing SCAQMD records. As part of my inspection, I also photographed a sign on respondent's white GMC C7500 truck that advertised with the business name, quote, Everardo's Tree Service, unquote. So with that, I do believe that there is ample evidence that there is good cause to issue an order for abatement. I think that the evidence, which is properly presented to us by affidavit and may be considered as the same evidence as if, by rule, as if these witnesses testified orally in front of us, that this evidence shows, number one, that there exists this engine, number two, that it was used improperly on 2 occasions, number three, that notices of violation were personally served upon the respondent, that they were properly served upon the respondent, that this engine is a Tier 2 engine, that best available control technology is now a Tier 4 engine, and that there is no permit. In particular, that there is no permit for this wood chipper, and that a permit is required, given its horsepower, and that therefore there is a direct violation of district rules. Any other discussion? There's some. Yes,
I just
Ms.
wanted
Barrett.
to say one thing, and you mentioned this at the beginning, when businesses operate in violation of district rules, that they are at an unfair advantage over businesses that are actually following the rules. And that is something that we discuss probably every time we hear this type of case. I would also like to address the fact that legal or illegal, and that's not an issue. I won't say it is an issue. I don't want that to be what we're saying. The district has a responsibility to clean the air, and the rules exist for that purpose. And it really doesn't matter the status of a person who is violating the rules. They're violating the rules. And I understand, I am sensitive to the feeling that someone might be afraid to come here, but the respondent could send anyone. We haven't seen anyone. So, because all businesses operating who are having equipment that emits into the air, they have to follow district rules. This business also has to follow district rules. And for that reason, and the things that Ms. Prusak enumerated, I think that we could find good cause. I think every dot has been, every I has been dotted and T has been crossed. I also wanted to refer to Exhibit 2, that NOV. I appreciate seeing the back of the NOV. Typically, when we see NOVs, we see the front of the NOV, and the back actually is not the part where it's naming who the violator is, but it is explaining what an NOV is. So NOVs, when they're issued, also come with some information. We heard testimony that district inspectors did explain what the NOV was about, and then there's also written explanation of what the NOV is about on the back, and how to come into compliance, why you're getting it, that you're out of compliance, those types of things. Even explaining that you can request a variance. I didn't know that was on the back of the NOV. So I appreciate seeing the back of the NOV this time.
Senator.
I'm glad you brought that point up, the back of the NOV, explaining what an NOV is all about. And it's in English. The individual here is Spanish. May not understand. May I finish, please?
I didn't say anything.
I don't see it in Spanish. So therefore, it's not yet convinced that they clearly understood, nor have they been served in a way where they put it in their hands. I'm not going to take the position they're avoiding service. They may be avoiding service. But it's also been stated early on that this equipment is not permittable, that they're going to change the rules. Air Resources Board would probably change the rule, as has not been yet noted, where this equipment will be permitted. And maybe I didn't hear them clearly, but I thought that's what he said. In any case, it's he's prohibited from using this equipment under any circumstances at this point in time, whether he respond to the notices or not. Unless and until such time the Air Resources Board makes some changes, he's got to go out and buy new equipment.
That is incorrect. The proposed order actually gives my question to Mr. Tomasovic is, why is this not just an out-and-out ban on the use of this engine? And Mr. Tomasovic's answer was that it is not, because he's trying to leave the door open. The district is trying to leave the door open for the respondent to be able to use this, should he be allowed to use it in the future. If you look at the proposed findings and decision, it reads that respondents to immediately cease and desist from operating the engine, et cetera, until such time as respondent submits and the district accepts a complete application for a permit to operate the engine. The violation at issue here is a failure on respondent's part to properly permit his wood chipper, or respondent's wood chipper, if you're looking at it as the respondent being a company. But it is an individual who's named. That is a requirement. The point is that it cannot, under current rules, be permitted because it is a Tier 2 and Tier 4 is required as best available control technology. However, if were we to vote for and adopt the proposed findings and decision today, the proposed order for abatement, it would in fact allow respondent the opportunity to attempt to permit his engine. And thus use the equipment should the rules change.
Should the rules change? The rules that today says is not permittable.
That's exactly right. So under today's rule, he's in violation.
Today's rules is not. That's what I said early on. It's not permittable. It's not a Tier 4. It's a Tier 2. That's not permittable.
That's right.
So therefore, if anything is clearly understood, the respondent may be saying, I can't afford to buy new equipment, which is no excuse. I understand that. But the fact of the matter is that why he's not appearing, I don't know the facts.
I did want to address the fact that the NOV is in English. Testimony was, and we did hear testimony last time we met, that the inspectors spoke to this gentleman in English and Spanish. So, as well as the son, of course, spoke English.
That is correct.
And in doing so, explain the nature of the notice of violation.
There are a couple other findings we need to make, as Mr. Tomasovic put in his closing. The respondent is in violation, and just to be clear, the violation is in not permitting his engine. The discussion of whether that engine could be permitted is beside the point. The violation is the operation of an engine that is not permitted, either under PERP rules for the state or under South Coast Air Quality Management Rule district rules. So that is the violation. The order for abatement will not constitute a taking of property without the due process of law. We have now had 2 hearings, 2 opportunities for respondent to be heard, a full hearing on this, so this is not a taking of property without due process of law. And I think, as Ms. Byrd pointed out, I do hope that the respondent is watching the proceedings, and the respondent understands that this board does take into account financial situation of small businesses and would have in the drafting of an order for abatement had he appeared. And number 3, the order of abatement results in if it results in the closing or elimination of otherwise lawful business, such closing would be without a corresponding benefit in reducing air contaminants. As Mr. Tomasovic stated in his closing, we don't have more evidence than this, but this is just a wood chipper, and it is a tree service. So it's not clear to me that this would be a closing or elimination of otherwise lawful business, just a prohibition on using a piece of equipment for which there is no permit. But such closing would not be without a corresponding, such closing would not be without a corresponding benefit in reducing air contaminants. Ms. Byrd, as I think you pointed out, the district has a lot of very small sources, and many of its rules address those little sources. And every one is important because when they add up to a lot of pollution. That's why there are rules that address all the very many dry cleaners and rules that address all the very many small gas stations. And in fact, there are rules that address all the smaller pieces of equipment and engines that fall over a certain horsepower and just simply require that they meet the best standard and that they be permitted. So I can make that finding that it would not be without a corresponding benefit in reducing air contaminants. Any other discussion on the merits? Seeing none. Anyone would like to make a motion? I can make a motion.
All right. Air Resources Board requires a Tier 4. This is the Tier 2. It may be important to note when it was changed from Tier 2 being legal to Tier 4. As we've learned in the past, based on discussions here, the 1110.1, something new and hard to be in compliance with. This is a good example. So therefore, if they decide to change at some subsequent day to legalize and make it possible for Tier 2 to operate and be permitted in this district, well, then that would be legal. And if you fail to do so, then there's a real problem there, as it is here apparently.
Rule 1110.2 does not apply here, different engine. However, I do want to point out again that were we to, there's no motion yet, but were we to adopt the proposed order, it would allow for any changes in the law. And that the violation, again, is not of Tier 1, Tier 2, Tier 3, Tier 4. The violation is a failure since at least 2015 of this respondent to permit the engine. Had respondent done so years ago, then perhaps their engine would be permissible today. However, they were in violation of the law for at least the last 2 years, 3 years, almost. And as a result, now they could not possibly permit a Tier 2 engine. But that is not the district's fault. That is not the community that breathes the air fault. That is the fault of the respondent who has been in violation for 3 years at least. Ms. Byrd, did you have something to add? I'm going to make a motion, and then we can have a discussion on the motion itself. In the matter of South Coast Air Quality Management District versus Everardo, Avalos, Lopez, case number 6090-1. I move that we grant the proposed order for abatement based on our ability to find good cause, based on the evidence presented, and to make the other findings in our Rule 806 as I just went through them. I further move that we adopt the proposed findings and decision for an order for abatement as proposed by the district, that we change it to reflect that, number one, that it was heard today as well as October 25th, the reasons why it was continued, and that respondent did not appear at either hearings. I will also at some point, if it does pass, ask Mr. Tomasovic if he could do the form of the findings, and that the findings of fact reflect the basis for which this hearing board actually did determine to hear the case in the absence of respondent being present. And further, I move that we add on page 4 in paragraph number 1, the date of January 9th, 2020, which should be 3 years from the date of the second NOV. And that completes my motion. Is there a second?
I'll second.
Is there a discussion on that motion? Any discussion?
If it's
Senator.
appropriate, question just came to my mind is, did the inspector share with the respondent that this is a Tier 2 engine and therefore not permittable by the state law? There's no evidence that that was done at all. And there's another possibility, not that I know it to be a fact, that if this individual acquired this engine from someone 2014, beginning of 2015, he just bought it used, would not have known at that time yet that it was not permittable. And if that were the case, too bad he's not here to say that. If that were the case, then of course I can see why, another reason why we'd be upset and disturbed.
Senator, if I may respond, I don't believe it's relevant. I'm not sure whether that was explained and if another board member has that handy. However, the violation for which my motion is based upon is the failure of respondent to permit the engine. It is not a failure to have a Tier 4 engine. It is not a failure to have a Tier 2 engine. And in fact, the findings and decision and the order for abatement would allow the respondent to remedy that violation if it's at all possible. Whether that's possible or not is really irrelevant. What's relevant is that he has been in violation since, and he is in knowing violation, given the evidence, since 2015.
On that note, you failed to apply. Is the engine permittable is the question.
Currently, it is not. It is irrelevant, well, and that is a stronger case. If you are operating an engine that is not even permittable and you don't carry a permit, that is a pretty egregious violation in my mind. Any other discussion, Ms.
I
Brady?
was just going to mention that the notice of violations themselves support what you're saying, that there's operation of the engine without a valid permit, and that is the violation. And that is the violation as noted on both notices of violation.
I just want this board to be very careful at attempts to supply a defense to a person who, for which there is overwhelming evidence of a violation. I think it is our job to hear cases fully and fairly, and certainly to give respondents an opportunity to be heard fully and fairly when they show. But certainly to receive all evidence, but to uphold district rules when there is clear and overwhelming evidence of a violation. That's all I'll say. If there's no other discussion, then I'll call for a vote. Mr. Camarena, how do you vote?
Yes.
Ms. Byrd, how do you vote?
Yes.
Dr. Lerner, how do you vote?
Yes.
Senator, how do you vote?
No, because I don't think, no proof of service.
There, just for the record, there is a proof of service. But whether or not you believe, despite the law that allows it, that is sufficient notice, that's a different issue. Is that
Right, it's substitute, he was not directly served.
okay? Then the motion passes 4-1. Mr. Tomasovic, would you mind reflecting the changes to the proposed order for abatement as they were stated?
No, Madam Chair.
Okay. So with that, motion passes 4-1, and the order is granted. Any other business, board members? Seeing none, we are adjourned. Thank you.